This bill permits grand juries to issue reports and will provide for a process of review and acceptance by the Superior Court for dissemination to the public. This was quite the topic for some years, and it has culminated in this bill, which I think may assuage the issues on all sides. Thank you.
Thank you, Senator. If there are no questions from committee members, we'll begin with our public testimony. Kyla Pecchia from the AG's office, Mike DeLauro, and Randall Rose.
Good evening, Madam Chair.
I think you've heard the instructions already. You may proceed, Kyla.
Thank you so much. Good evening, Madam Chair, and to the committee. Thank you, Senator Archambault, for being our sponsor again this year on this legislation. This is our third year that our office is proposing this bill, so we hope that it is the charm this year. And before I start my remarks, I'd just like to say the Deputy Attorney General asked me to apologize. She wanted to be here and testify, but her schedule didn't permit her to do so, so you got me instead. Anyway, so I essentially just want to start out by saying again, and I think Senator Archambault said it well when he introduced the bill. This has been a topic of conversation for quite some time, and I think I'd like to underscore my testimony first by saying that the intent of this bill is to just go back to promoting transparency to the public of things that happen in the courthouse and things that are perceived to be happening behind closed doors. So this bill would amend the grand jury statute to allow for the issuance of grand jury reports in certain cases. Under Rhode Island law, as many of the members of this committee know, grand juries have the authority to investigate crimes and return indictments. However, aside from returning those indictments, they have no mechanism for reporting on their findings. And furthermore, the rules of criminal procedure are very clear with respect to grand jury secrecy. Our research indicates that there are a number of other states and the federal government that allow grand jury to issue reports in certain circumstances with notice to named individuals and a number of very important procedural safeguards that are imposed by the courts. So first I'd like to go bigger picture and then we'll go narrow for a second. So this bill would allow statewide and county grand juries to issue reports pursuant to the following process. Reports are to be submitted only with the consent of at least 12 of the grand jurors. So that's the same number that's required to vote to bring an indictment. Usually, I think pursuant to Rule 6 of criminal procedure, there can be 13 to 23 jurors impaneled. So it would require the consent of 12 to issue a report. Any individual or entity that is named in the report would be notified in advance of publication and given the opportunity and due process to respond or object to the release or seek a redaction. Those individuals would also have the right to appeal a court's decision with respect to release or redaction, and our office would also have the right to petition the court to not allow the issuance of a grand jury report in a certain fashion with the redaction. So within that process, in order for the report to be released, the presiding justice would have to be satisfied that a number of requirements are met prior to authorizing the release of that report, those being that the grand jury was properly convened in the first place, that the facts in the report were revealed in the course of grand jury proceedings and are supported by a preponderance of the evidence, which is the same standard used in civil proceedings, that the report does not contain personal materials that are unrelated to a lawful grand jury inquiry, that it does not disclose certain confidential information like informants, and that the release of the report does not prejudice fair consideration of criminal matters. So why is this bill important to our office? As many of us know, you pay attention to the news, you know that sometimes grand juries don't always return an indictment. And we want the public to be able to know what occurred during those deliberations because we think in certain circumstances those would be in the public's best interest to know that information. Examples of where that might be the case: officer-involved shootings, police use of force cases, and potentially cases involving public corruption. So those are all instances where potentially there are no criminal charges that could be brought, but there is a great public interest in learning what's happened. And I think that sometimes, and I don't speak from a position of privilege as an attorney, but I think there are some times where the general public just doesn't understand the legal process and why a grand jury had arrived at a certain conclusion. And so these reports would really help us to explain what happened to the general public. And again, just promote that transparency and restore confidence in the criminal justice system. And I would also be remiss if I didn't mention that there is a sunset provision of 5 years built into this bill. So we felt that including that in the language of this bill was an important safeguard. And with that, I will conclude my testimony and answer questions.
Thank you very much. Any questions or comments by committee members?
Nice job.
Thank you. Randall, you're next.
Thank you, Madam Chair and members of the committee. I am in favor of the bill. I do have some concerns about it, though. So the grand jury is a multi-headed institution. To some extent, and a lot of opposing burdens are placed on it. To some extent, it's meant to keep innocent people from being criminally charged, so that it limits the power of prosecutors. In another way, it enhances the power of prosecutors by allowing them to gather more information under looser rules. So it is a institution that's asked to bear several different purposes. I understand there are concerns about how a grand jury may be investigating some ordinary fellow and find no reason to charge them, but the person who's under investigation may worry that information is going to be released in the grand jury report that damages their reputation, even though the grand jury did not find enough reason to charge them. I understand that concern. However, as the previous witness pointed out, there are some types of cases where it is very much in the public interest for this information to be released. And I would say, in particular, when the grand jury is investing a public figure on corruption, possible corruption charges, or the situation we found a few years ago with 38 Studios, where the grand jury got a lot of information that was being held up from being released. In these cases, it very much is in the public interest to have a report released, and the subject of the investigation has less right to complain by virtue of being a public figure. So I would say that I support the bill if it's limited to cases, if it's explicitly limited to only certain types of cases. At a minimum, it should be limited to cases involving public figures and possibly limited further to the specific types of cases mentioned by the previous witness. That should be in the language. For officer-involved shootings, I can see the value of releasing it, but with officer-involved shootings, the main public concern is, did the prosecutor play fair before the grand jury? Did the prosecutor really make an effort to see if charges could be brought? And that issue could be better addressed by releasing the grand jury transcript in redacted form rather than a report written by the prosecutor. So I would suggest those changes, but the general thrust of the bill is a good one. Thank you.
Thank you very much for your testimony. Any questions or comments for Randall? Seeing none, Mike, if you want to proceed with your testimony on this bill.
Yeah, I'll be brief. I'm just here to answer questions. I did this morning, I think, sent the committee 2 documents. We're just suggesting that before the body, before the committee takes any action, that you take a peek at the.
You would think I'd never done this before. It's late. Yeah. Madam Chair, let me just start over. That was just so embarrassing. So this is the 3rd year this bill has been pending. We've never taken a position on it. Each time, though, we've expressed some, I don't want to say concerns, but have suggested that the committee has some materials in front of it that it ought to take a peek at before it takes any action on the legislation. This morning, I think I emailed the committee those 2 documents. One is a report from Pennsylvania that from November of 2019, where they have this in Pennsylvania, and they took a look at whether or not they wanted to continue doing it or not. The other thing that I gave you, more importantly and closer to home, is the Rhode Island Supreme Court's decision in Ray 38 Studios. I just direct your attention to page 235 of the Supreme Court's decision, and I think that pretty much says it all. The grand jury reports is also is in section 5 of the from Pennsylvania. And again, I emailed it to you guys, I think this morning. Happy to answer any questions you might have.
Thank you very much for your testimony. Any questions or comments? Okay, very good. Thank you for your testimony. With that, I entertain a motion to hold further study 2777. So moved by Senator Lombardi, seconded by Senator Reptakis. May I have a roll call vote, please?
Chair Coyne.
Yes.
Senator Archibald.
Yes.
Senator Reptakis.
Yes.
Senator Burke.
Yes.
Senator Oyer.
Yes.
Senator Lombardi.
Yes.
Senator Quezada. Senator Rogers. Yes. Unanimous.
And 2777 is held for further study.